Then comes another law that came under huge criticism, and that is TADA, the Terrorist and Disruptive Activities Act of 1985. In fact, is that enactment which for the first time focused directly upon this menace of terrorism. The enactment was implemented optimally against the Khalistan movement and also against the Bombay blast cases. Apart from punishing the actual perpetrators of terrorist activities, the Act actually widened its scope by way of criminalizing the concealment and harboring of a terrorist, even if it was done without any knowledge or intention of doing so. The enactment in fact created two new forms of offences which could come under its ambit, namely, firstly, the Terrorist Act under section 3, for which the offender could be imputed with the intention to commit the offence, and the second category was of causing disruptive or committing disruptive activities, which were covered under section 4. TADA imposed many number of restrictions upon the accused, including on the grant of bail. Special courts were set up only to consider these bail applications, and they could grant the bail only if they found reasonable grounds that existed in favor of accused and his innocence. So unless innocence was proved on the prima facie fact of the case, bail could be rejected by the special courts. In 1987, an amendment was made to this enactment which brought with it many number of changes to the enactment and further increased the powers of the authorities or the law enforcing agencies under the enactment. To name few of such changes that increase the authority of the agencies involved under the Act are: firstly, it allowed judicial admission of confessions that were made by the accused in police custody. Secondly, it reduced the standards that were required for positive eyewitness identification. The identification based on photographs in the absence of the accused were made admissible in the court of law. Thirdly, it shifted the burden of proof upon the suspect, which was contrary to the general principle of criminal justice system of our country. A person found in possession of arms or weapons or any other incriminating substance could be held liable under the enactment with stringent punishments. In Kartar Singh was the state of Punjab in the year 1994, the Supreme Court in fact struck down section 22 of the enactment. It was this section 22 which allowed for the conviction based on the identification, which was further based on a photograph in the absence of the accused. The court also gave certain suggestions to safeguard the accused's interests while being dealt with under the law. However, in spite of these laws and the judicial interventions, the law continued to apply, and after lots of criticism from both international as well as national NGOs and other international organizations, the law was repealed in the year 1995. What followed the repeal is yet another law almost similar to the earlier law, and that is POTA. The Prevention of Terrorist Act of 2002, commonly known as POTA, replaced TADA, the earlier enactment. Most of the suggestions given by the Supreme Court of India in Kartar Singh's case were in fact included under this new enactment called POTA. POTA provided for the measures to deal with the organizations which were formally declared as terrorist organizations. It criminalized taking membership with such organizations. It also criminalized giving direct or indirect support to these organizations, including funding the activities of these organizations. POTA even provided for speedy trial of the accused cases and also introduced quasi-judicial system so as to review the state's actions under the enactment. The Supreme Court upheld the constitutional validity of this enactment in the case of People's Union for Civil Liberties versus Union of India in year 2004. And it also gave directions to be followed in order to avoid abuse of the provisions of the enactment. The court also insisted for proof of requisite mens rea before imposing liability for the acts of abetment, so as to also punish for possession of arms and such other incriminating substances mens rea had to be now proved because of this direction of the Supreme Court of the country. Mens rea therefore was insisted upon before punishing for any acts that were covered under the enactment, including for getting the membership of these banned organizations. It's true that POTA and TADA both, or POTA like TADA, provided for the establishment of special courts which were empowered to try cases of terrorism. It had to work like a fast-track court, thereby compromising various rights that accused otherwise gets under our constitution and are under our criminal justice system, including our criminal procedure code. The trials in the absence where accused were also conducted in many cases. These were allowed by the higher courts, and evidences were recorded in the absence of witnesses in many cases. Evidences of witnesses were recorded in the absence of accused also in many number of cases. For all these reasons, the Act came under serious criticism, as most of the procedural safeguards and the rules supposed to be followed in any criminal case were all compromised in this case, and these were against the legal and the constitutional rights that are otherwise guaranteed to an accused of a criminal case. In addition, the power to arrest under the Act was abused and misused by many police as well as members of the armed forces, which resulted in gross violations of human rights of people. Finally, because of all this, the Act had to be repealed in the year 2004. But the repeal of the Act did not stop the problems that were faced by many number of accused who were charged and already booked under the enactment, because the repeal did not come with a retrospective effect. So therefore, the cases that were already pending continued to be considered as the cases that could be dealt with under the earlier law. Now let's look at the laws that currently applies at the national level. Currently, though there is no specific law that deals with terrorism as a separate and a segregated menace, yet we have many number of laws which taken togetherly forms to be a very wider and comprehensive law framework to deal with terrorism. The existing provisions of Indian Penal Code also can be added to this set of law that deals with terrorism. In addition, we have special laws including the Arms Act, the Explosives Act, the Money Laundering Act, the Information Technology Act, etc. After 2011 Mumbai attack, we had a lot of laws that underwent amendments, thereby making the application of these laws much more wider than before this incident that happened in Mumbai. Let's look at some of these laws in brief. The Indian Penal Code, which is in fact one of the substantive criminal law of our country, has a lot of chapters that deals with many forms of hate crimes and many forms of offences that are committed against the state or the society. Some of these can also be considered as the provisions that can be used to tackle terrorism. To name few, Chapter 4 of the Indian Penal Code deals with offences against the state, and sections such as 121, 121A, 122, 123, 124 and 124A can all be invoked against terror attacks. On the other hand, we have Chapter 8 of the IPC, which deals with offences against public tranquility, and this contains the provisions that can be dealt with especially in cases of offences such as unlawful assembly or rioting. These have also been invoked against many offences relating to terrorism. Specifically, provisions such as 153, 153A, 153B, 157 and 158 are the relevant provisions under this chapter. Then we have Chapter 15, which deals with offences relating to religion, which can also be utilized in certain cases. And the relevant provisions of this chapter which can be so utilized are sections such as 295A, 296 and 298. Now, after Mumbai terror attack, the Parliament passed two important bills. One, to set up the National Investigation Agency, which has special powers today to deal with terrorism, and the other was to amend the law so as to provide for stringent punishments for acts of terrorism. Coming to the National Investigation Agency Act of 2008, which was enacted on 31st December 2008, With that came an institution that was set up in our country called the National Investigation Agency. The National Investigation Agency functions as the central counter-terrorism law enforcement agency in our country. It aims to investigate and prosecute offences affecting sovereignty, security and integrity of the country, the friendly relationships that exist between India and other foreign states, and the offences under which the acts are to be enacted so as to implement international treaties, agreements, conventions and resolutions of the United Nations and other international organizations, and for the matters connected therewith or incidental thereto. Now, according to the National Investigation Agency, the manner of Constitution rules of 2008, the National Investigation Agency has to provide assistance to and should coordinate and also should seek assistance from the other intelligence and investigation agencies that are working across the country in association with both state as well as central governments. The Act also provides for setting up of special courts for speedy trial of terror related offences, with hearings to be held on day-to-day basis. The officers of this agency from above the rank of sub-inspectors are empowered with the power to undertake the investigation. They have power to pursue and investigate cases of anything to do with terrorism throughout the country. They are entrusted with all such duties, privileges and liabilities which any other local police officer would otherwise have in connection with any other offence.